614 Startups Nation, welcome back to Ask an Expert. Today I have our legal contributor Demetrius Robinson of KJK with us to discuss the top legal mistakes startup founders make. All right, Demetrius, on to mistake number 3. Let's talk intellectual property. Where do we go wrong?
Yeah, great sort of segue there, Elio. I think the mistake that founders make as it relates to intellectual property is twofold. One is not understanding that they actually are creating intellectual property, and so trying to make sure that they maintain and protect it. And then 2, infringing on someone else's. And so I'll talk through sort of the first one first, because that has probably the greater financial impact than maybe the other one. And I'll tell a quick story to sort of illustrate that. But, when you infringe on someone else's intellectual property, whether you intend to or not, traditionally they don't enjoy that. And so they try to take some action against you to protect their own intellectual property, right? So they don't want you sort of confusing others or creating an environment that is costing them financially. And I'll tell a story about, I won't sort of use the client per se, but there was a major brand who has a festival out west pretty consistently. We'll just call it Coachella. And they, like to protect that brand as is natural of any organization. Unfortunately, I had a client who may have had a very similar name, but was definitely not in the same space. And so, they reached out and said, hey, we think you're infringing on our intellectual property, and we want you to stop. And luckily, we were able to sort of help articulate to them that was not the case, and so they should move on. And they did. They moved on, and no legal action was taken. But I think that is important to think about, because if you're infringing on someone else's, they're going to try to take action to protect it. So how do you prevent that? So the first thing you kind of want to do is do some sort of trademark search, and that is usually you can do through a USPTO office, and that sort of just articulates, hey, does someone else have this trademark? Or do a search, right? So if you've done a search online and you come across a particular phrasing or name or something like that, just know that name may be protected. Now that doesn't mean you can't use it, right? Because they may not have taken actions to protect it globally, right? So a small company only doing business in Ohio may have a name, but they only use it in Ohio, versus maybe you're a global company and you intend to be global. And so you want to use it, that similar name, globally, and they've not taken action to protect it. So there may be opportunities to sort of get in front of them, or carve out, hey, we will do everything, but we won't do Ohio. And we've helped negotiate some deals like that as well for clients where, hey, we're bigger than you. We'll let you use it, but we want to use it too, and kind of go from there. So just something to think about is how do I look to make sure no one else is doing what I'm trying to do, and then make sure I'm not creating a name that creates value that then turns out to be infringing on someone else's, and then I got to start all over. So that's the first thing. The second piece is, as you're sort of looking to create intellectual property, are you taking the steps internally to protect your intellectual property, right? And so that means sometimes filing patents, trademarks, placing copyright marks on, or service marks, and that can be done federally. That can also be done usually state by state as well. Just know that if you do it state by state, then that only means it's protected within the boundaries of that state's jurisdiction, versus if you do it nationally or internationally, there's a way to do that, then it's protected, potentially globally, or at least, nationally throughout the United States. There are cost, obviously, differences between those two. And when you think about intellectual property, some people just think, well, it's just the name and I only need to protect the name. But in reality, the way the USPTO office works is you actually protect the name in various categories. So, if it's merchandise, then that's one category versus a podcast is a different category, right? So you're only protected in the categories in which you file the protection for as it relates to the USPTO office. So yeah, just something to think about sort of as you go about your day there. The second and sort of last piece is if someone has, started to infringe, what steps do you take, right? So there's legal actions. Sometimes we've sent what's called a cease and desist letter. They just put someone on notice that says, hey, we appreciate everything that you're doing, but unfortunately what you're doing is actually infringing on my rights. So we're just asking you to stop doing that. And if you don't stop doing it, then I will probably take legal action against you. And so that is just something to think about. One is if you're going to do something like that, right? So cease and desist, just be prepared to go back and take that action. Because if you don't, then it means nothing. And pretty soon everyone will sort of get word that you don't sort of follow up on that. The other is, especially as it relates to your employees, your third-party service providers, things like that, make sure you're putting together confidentiality agreements and sometimes called NDAs, or if you're employees specifically, confidentiality and invention assignment agreements. So that anything that they're creating within your organization or supporting your organization, you own. They don't own individually. A lot of states have that sort of automatically, but not every state does. And sort of just as an extra layer, it's helpful to put that document in writing that says, hey, if you're creating it under my roof, it's mine. If you're using my my goods, my services, my supplies to create it, it's also mine. So.
Yeah, outstanding. Demetrius, thank you so much for your insights. I know a lot of startup founders, when you're first starting, you probably play a little fast and loose with equity because, hey, the company's worth zero, right? But you still need to talk to an expert. Just like that, early on, your brand, your product, your intellectual property, whether you think it's worth zero today or not, it is still something worth protecting. And if you have that question in your mind, then you need to ask an expert. So reach out to Demetrius Robinson of KJK. All right, folks, we're here answering your questions, so stay tuned. We'll be back soon. That's a wrap, folks. You can find this and all our episodes on our website, 614startups.com, Apple Podcasts, Spotify, Anchor, and all your favorite podcasting platforms. Don't forget to subscribe and write a review. If you'd like updates sent directly to your inbox, you can sign up for our weekly newsletter on the website. To engage in the 614 Startups community, follow us on LinkedIn, Twitter, Facebook, and Instagram at 614 Startups on all platforms and join the conversation. For sponsorship opportunities and collaborations, email us at info@614startups.com.